We are live today. This is my inaugural stream on this particular platform. Trying to get in here with the Makosi Mediations, talking about things that are related to mediations, court, and the like, but trying to see if I can have a more casual, I shouldn't even say more casual, a little more professional over here on talking strictly about the courts, the court systems, how they work, how it is that we interact with them, what the benefits are, what the detriments are, I guess, the pros and cons. That's how we would like to talk about things. And that's one of those things I really want to get into today is just talking about some of those pros and cons. Give it a little longer form content than what we've been doing here recently, which is just a short hit 'em and quit 'em, posted on Instagram, posted on YouTube. Trying to get it down a little shorter so we can get it a minute or under, so I can actually get those shorts in as they're supposed to be shorter than that. So I can, 60 seconds or less, right? So almost like hostage negotiation, I guess. So here we are. Here's where we're at. Here's what we're going to be doing. And I guess right now, what I want to do, I just want to hop in. Let's get on the other side of the break. Once we get on the other side of the break, we'll talk about this little topic on why the courts really aren't that helpful. You've seen the thumbnail. You know what it is that we're talking about. We're going to get. So yeah, we're back after it. But as a long story short, is a lot of things that we deal with in the court system. If you've ever dealt with it and you are not an attorney, you're not somebody who has a lot of experience in the legal field. It can be quite daunting. It can be extremely frustrating because many times the courts are not the most helpful of places when trying to go through this whole process, this litigative process that you're going through. And it's not really that helpful if you're what we call a pro se or someone who's representing yourself and you have no legal training whatsoever. You might go in there, you want to file your paperwork with the county clerk, and you might have a question, and and it's a simple question, something that you just have a quick question. County clerk says, "Hey, that's legal advice. I don't give any legal advice. Can't help you out there. I would recommend you call an attorney or contact an attorney." Likewise, you probably find yourself in court and you are pro se. You're representing yourself. You are what they call a pro se litigant, and you see some things going on. There was something that was highlighted by another famous legal YouTuber here recently, where they pointed out the fact that in that court case, the judge was asking, but not in a direct way, if the person wanted to file a motion to dismiss the case. That was all that was really necessary. But the judge cannot come out and say, or would not come out and say, yeah, this case should be dismissed. Are you filing a motion? File a motion to dismiss it. And the person could have orally filed that motion on the record, or they could have had as a requested permission to file it written if that's what the court required. But not knowing that process and not being told directly, it's not very helpful to that individual to have that case dismissed. Not enough evidence, not enough information that was there in order for them to do that. And so you look at cases like this or instances like this as you're navigating through this whole legal system, and you're wondering, why is it that if the court wants me to go through this process, why is it that they're not more helpful? And I guess the easiest thing to do at that point, in order to help you to understand it and help to explain this, is to take a step back, get out of your own shoes, so to speak, and look at it. Would you want the court to help the other party in their case against you? Normally, for most people, that answer is no. You wouldn't want the court helping them. Why is the court helping them? Why is the court telling them what they need to file? Why is the court telling them? And when I mentioned the court, I talked about the district clerk's office, the clerk's office, and all these different aspects of it that go into this legal system. This whole mutually reinforcing system of institutions around this legal portion of it that's there is what I'm referring to when I talk about it. So here you have a situation where you wouldn't want the court to help the other party out. It's like, why are you telling them what they need to file? Why are you telling them what motions they need to do, right? And you would be upset and you would be angry about it. And the same goes for the pro se litigant. If you're a pro se litigant and the other party is a pro se litigant, no big deal. Neither of you guys really know. But at the same time, it would be a lot more helpful, a lot more instructive if the court, which knew what it was they were looking for, actually told you. However, the court's goal, the court's role in that entire process, right? So their goal is to get to the end part, but the role that the court plays is they are to be neutral. The court is to be neutral in the process between the two adversarial parties. They're not supposed to take one side, and they're not supposed to take the other side's position as well. So you're looking at a situation where the court takes a very hard line stance on being neutral and not giving one party a leg up and not doing the same for the other party. There's a thing in the courts where they talk about what was referred to as ex parte communication. In other words, you don't in the courts you don't want to have communication with one side and not the other. That's ex parte communication. All sides need to be in there. If it's outside of court that you're talking, all parties need to be involved in it. Otherwise, that's something that can be referred to as ex parte communication. And again, as I'm talking about these terms, one of the things I did not express and I needed to express explicitly initially is that this is not legal advice. We're talking about legal topics, legal subjects, kind of tip for the days in dealing with legal subjects as we're doing it, but we're not giving any kind of legal advice. We're just talking about the court system, how the court system works, specifically in regards to trying to get to the end of that process. And I like to talk about mediation and other forms of alternative dispute resolutions because these are portions of that process that can help you skip to the end of the line, right? And if you've seen some of the earlier videos that we've done on this that were scripted, you obviously know that mediation or ADR, alternative dispute resolutions, which includes mediation and arbitration, other types, will help you to skip to the end of the line by giving you an award or a mediated settlement agreement or something else that will help you skip to the end of that process to allow you to be done with it in court costs and to be done with that and to have some kind of relief, I guess you could say. Whether the remedy is what you want it to be or not, you'll have some kind of relief at the end of it. So that's the primary reason on why it is when you're looking at the courts, why the courts are not really helpful. There's also the added deal, and that would be the outstanding reason or the primary reason that would be a good reason why the courts aren't helping. But another one, like I say, that many people probably guess at is pretty much a pay-to-play system as well. It's a system where if you didn't go through law school, there's a lot of people who paid money in order to get it, and they don't want to sit there and see their livelihood jeopardized by the courts just willy-nilly handing out information. So there's also that goes into that process as well. And we don't want to ignore the 800-pound gorilla that's in the room. I almost said elephant. If you had an 800-pound elephant, that would also be sight-worthy because that would be an emaciated elephant. So I'm going through this entire process and looking at it from start to finish. If you're not represented and you have some idea of how the law works, great. If you are represented, that's even better. Attorneys do have a place in that process. Granted, attorneys are very expensive. However, you might have it where you can go talk to an attorney, pay them a certain amount of money, or maybe if you're a small business where you have an attorney on retainer, and prior to asking them to commence legal action on your behalf, it might be better to ask them how to go about that process and let them know that there might be something that's going to come on their radar very soon as far as the legal process. And depending on the type of attorney that you have, and this is something that we can get into later on in talking about whether or not you have a good attorney, how to look for an attorney, how to determine whether or not the attorney that you have is actually serving your interest. And that's something that a lot of times that we can definitely do is trying to figure out whether or not the attorney that you have is actually serving your interest or not. And what I want to do right now, and I guess what I should have done in the beginning, is to get a link for you guys. Let me do that here. And where is that link for me? Give me one moment here. I am struggling streaming right now. There we go. So let me drop a link for you. And this will allow anyone who wants to, if you're out there and you're listening to this right now, if if you want to hop on in, by all means, come on in, and let's talk about this whole process of this legal conundrum, so to speak, of trying to get through this process, and the courts not being very helpful. And it's something where, as we're going through it and as we're looking at it, if you're actually interested in hopping on in and you want to talk it through, if you have an additional question, something I might not have addressed at this point, by all means, come on in and let's talk about it. So yeah, as we're waiting on people that may or may not want to hop on in here, let's talk about this process of selecting an attorney, having an attorney that you can work with throughout the process that you're going through, right? Because ultimately, what you do want and what you're looking for here is an attorney that will work with you, an attorney that will see the issues that you're having. And what I always tell everybody, there's this old expression, I heard it on multiple occasions. I don't know where to give attribution for it but where many people begin to talk about, you want an attorney that has a mind or a heart of a teacher, someone who's willing to impart the knowledge to you, give you the information necessary in order for you to go through this process, help you to manage your expectations as you're going through something which normally is a very stressful process for most people. If you don't deal with it on a day-to-day basis, if you're not looking at it on a day-to-day basis, this is something that can be extremely stressful for you. And it's something that many people, when we look at it, we see it, we acknowledge that this is a process that we want to get into. But the level of stress once you actually get into it is something that people just normally aren't prepared to address. Normally, they're just not prepared for it. And this is a situation where you want to definitely be prepared for the process as you're getting ready to walk it through. And I don't see anybody coming in at this point. I don't want to just drag this on for the purpose of dragging it on. But I definitely want to make sure that instead of just doing a really quick short form, to take this process and to talk about it in the terms in which it needs to be addressed. Because a lot of times people think the court process is only that way because it's a monetary incentive for it. And the reality is that does play a part into it. I'm not going to minimize that and say it doesn't play a part, that there is a monetary incentive to it. If you practice law and you're not authorized, that's what they call a UPL, unauthorized practice of law, something that an attorney or someone who practices law will be quick to call or to report to try and get that individual sanctioned somehow by the court because it's messing with the church's money, so to speak. So you don't want to have that situation going on either. That being said, the primary reason, though, is that the court is to remain neutral. And if the court starts helping you out, the other side has a right for that ex parte communication or the assistance of the other party. These are things that you should know. These are arguments you should be making, not the court making them on your behalf. Knowing where it needs to go, and the judge in turn setting policy, or not just setting policy, but setting evidence in your case, as opposed to just ruling on whether or not the evidence is admissible or not. Looking at the procedures and determining whether or not this procedure is followed or not. I'll give you one more example before we cut out here. If you're in court and you're suing somebody, let's say on a tort, which would be the easiest one is probably negligence in talking about that. So in looking at it, let's say you're in the court and you're discussing something and you're dealing with negligence, and you don't know you've put it in the pleadings and your paperwork that you given to the court, and you're alleging negligence in this case, and you're suing on the basis and on the legal theory of negligence. You're saying the other party was negligent in whatever it is they did during an accident, whatever it is. The theory of negligence requires several things, and when you're looking at it from a statutory standpoint, and common law, it's going to be duty, breach, causation, which includes proximate and actual cause, and damages, right? So you have these things that are actually going to be these 5 things that need to be proven in order for you to succeed on your allegation of negligence. So let's say that for whatever reason, you as a pro se litigant, you actually knew enough to get in there. The other side didn't know enough to file a motion to suppress this, that, and the other as far as the evidence you want to bring in. You guys didn't have any hiccups. You actually are in court at this point, and you're in court with the other party, and you're able to prove that they had a duty, that they breached the duty to you, that they are the proximate and actual causes of it. And they say, well, what happened? Well, nothing really happened. It just, I mean, what they did was dangerous, and this really could have had really adverse effects on me. And they're like, well, were you shaken up or anything along those lines? No, we wasn't really too shaken up, but they were wrong in what they did, and the other side might listen to all of this and come in and validate all the stuff that you just stated and verify you didn't have anything. And they go, okay, well, even if, I say, instead of us mounting this whole defense, we're going to ask the court dismiss the case. They haven't proven all the elements. You go, well, no, we've proven that you needed to do it and all these things that you've done, and we have evidence that shows that you were da 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 da. But the last part of it, damages. You had no damages. You weren't damaged at all by the actions, and you've stated multiple times that you weren't damaged or whatever. And the court will look at it, and the court will go, yeah, you're right. There were no damages. There's no issue of fact. There's no issue of fact for the fact finder to disagree with. This is an issue of law, and that law, these are the things that you need to have, and the judge will dismiss the case. And all because it's something where no. Well, I had like an emotional trauma, and I went to go see the psychiatrist, and da 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 da. Well, now it's too late. And that's something where, depending on whether or not the case is dismissed with prejudice or not, or without prejudice, if it's with prejudice and you can't bring it back again, and if it's without, then you might be able to bring it back again and after the case is dismissed or before the court loses playing. Anyway, there's a lot of other things that goes into that process from that standpoint. But it's not up to the court to make those arguments on your behalf. As a matter of fact, the other side would have a valid case for saying the court was very partial and not impartial in dealing with you, or dealing with them rather, from their perspective and how they interacted with you, and having these situations where they go, well, hey, why don't you allege this also, and why don't you prove this also, and why don't you do this also? We have an adversarial process within our legal system, and that adversarial process requires that the adversaries face off against each other, and not only the adversaries face off against each other, the court is there to call balls and strikes, so to speak, and not to get in the middle of the plaintiffs and the defendant and the case that's between the two of them, or in the case of a family case, the petitioner and the respondent, in the case that's going to be between the two of them. So yeah, it kind of sucks in many ways, but there's a reason why the court is not more helpful. There's a reason why the court doesn't just jump in at every little part of the proceedings to help out the parties. And in understanding that and seeing how that works, it's very, 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 very instructive as to why it is you would like to have or should have an attorney with you throughout that process. One that you can at least reference and talk to about your case, even if it's going to cost you a little money in order to ask and talk about these issues, because it might not be worth the attorney squeeze. The juice might not be worth the squeeze for them in order for them to try your case and to go through this thing, and you're not really going to get anything back on it anyway. You're suing on principle. That's it. Any comments, any questions, or anything along those lines, by all means, put them down below in the comments, or you can put it in the chat box. Well, up until a few minutes, once I click, we're done. But in any event, that's where we're at. That's all I have for you today, and hopefully, you guys are having a very blessed day, and that you may always, always, always be blessed with peace. And with that, we are